Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On the 9th of October, 2024, the state of Idaho, in the Idaho versus Kohberger case, filed state's objection to defendant's motion regarding non-statutory aggravating evidence. And in a nutshell, this deals with an allegation of a lack of due process. It begins by stating that the state of Idaho, by and through the Latah County prosecuting attorney, objects to defendant's motion for court order requiring the state to, 1, provide notice of every alleged non-statutory aggravating fact, circumstance it may rely on at any sentencing trial, and 2, to prove beyond reasonable doubt every alleged non-statutory aggravating fact, circumstance, and then they have here in parentheses motion. And we know that this has to do with due process by the existence right away to provide notice. This is the first factor. Notice appears at the beginning of line 3, page 1. You'll recall that Mr. Kohberger has raised the issue of lack of due process pursuant to not only the Idaho Constitution, but also the federal Constitution, specifically the 14th Amendment to that federal Constitution, which is the Due Process Clause. And it requires that when a state such as Idaho seeks to take someone's property or liberty or life, that due process of law must be provided. And that has been interpreted to mean notice, opportunity to be heard, and also an impartial judiciary. And one of the times that we saw Mr. Kohberger infamously raise a lack of due process was the fireworks that happened in 2023 in Latah County when John Judge, on the state of Idaho's motion, entered what was basically a restraining order preventing Dr. Edelman, Mr. Kohberger's expert witness, from conducting surveys, and this related to the change of venue motion. We covered those filings that occurred in March of 2023 in prior episodes of the Indie Zone. So here we see, by virtue of this term, lack of notice, that Mr. Kohberger is essentially raising due process here. Now, the state, as with its other responses to Mr. Kohberger's filings of September 5th, 2024, which the state responded to on October 9th, 2024, raising the issue that Mr. Kohberger is making disingenuous arguments that have no basis in the law, and they're doing so here. They say here on page 2, under section A, Idaho's capital sentencing schemes sets the appropriate standard for notice. And they say here that they have complied. The state has complied with the statutory requirement. Not every single act is required to be submitted. Statutorily, they say, they have complied with the law and therefore with due process. Under section B, also appearing in page 2, the state says the state does not have to prove non-statutory aggravating evidence beyond a reasonable doubt. And this goes to burden of proof. Idaho's capital sentencing scheme, it says here, requires the state to prove at least one statutory aggravating circumstance beyond a reasonable doubt, but it does not require the state to prove non-statutory aggravating evidence beyond a reasonable doubt. And they cite to this case cited above here in page 2, section A of State versus Hall. This is an Idaho case. In Hall, the court reaffirmed that the fact finder in a special sentencing proceeding can consider circumstances not statutorily listed and not expressly found beyond a reasonable doubt. If you would like to review this document, which is once again, as we've seen before, signed by Jeff Nye, Special Assistant Attorney General, before Mr. Thompson, who is the prosecuting attorney, signed it, please go to the link that I have provided in the description to this podcast episode. This will now conclude this episode of the Indie Zone. Thank you for joining us. Please join us again.